Well, before I begin, I should remind people that we do propose to make an anonymity order in this case, not, of course, in respect of the party to the case, but in respect of the child. And I believe that's been agreed between the parties. So the court will order that no one shall publish or reveal the name or address of the child of the appellant, who is the subject of these proceedings, or publish or reveal any information which will be likely to lead to the identification of the appellant's child in connection with these proceedings. I always remind people of these orders because we are being live streamed. It's very easy for people to make a slip.
Yes, and you'll have seen the Court of Appeal used a letter, paragraph
Yes.
21 of their judgment.
Yeah, absolutely. Well, we might do something else. We may not have to refer. This is a very important point, Mr. Ford and Sir James, but I can't believe it's going to take two such experienced counsel all day to argue it.
Let's see.
Is that a threat or
Mr. Eady, Mr. Blundell, Mr. Fisher, instructed by Amir Mughal for the respondents. I'm here with Ronan Toll, Catherine Robinson, instructed by Stefan Vnuk of Duncan Lewis. Absent is Raza Hussain. He's on the statement of facts and issues. He is recuperating, and on behalf of all of us, I send him our love and our best wishes.
He was looking very well when I last saw him last week.
The facts are in the statement of facts and issues at bundle 62 to 66. I don't need to add anything or subtract anything. When I use numbers, there'll always be the electronic bundle number. We say, for the purposes of Part 5 of the 2002 Act, a human rights claim or a protection claim, which includes an asylum claim, includes subsequent submissions. It includes submissions and subsequent submissions that the Secretary of State may assess as clearly unfounded, or the Secretary of State may assess as matters that should have been raised in relation to a previous decision, or for that matter, a previous appeal. It includes submissions which are assessed by the Secretary of State as being indistinct, indeed identical to what was said previously, and it includes submissions assessed as having no reasonable prospect of success. And the distinction between that and clearly unfounded is an elusive one, but the House of Lords had that in ZT. We say under Part 5 of the 2002 Act, has decided to refuse includes rejected on the merits. And there's nothing in rejection as opposed to refuse that is a material distinction. And in the stated agreed issue, you'll see the way it's put is a decision in response. That's at page 67. Why do we say all of this? Firstly, because it's the ordinary and natural meaning of the words in what is now a very straightforward statute. Secondly, we say this because reading in Lord Bingham, or Sir Thomas Bingham as he was, the acid test, we all know, from Onibio in the 1990s, is a gloss. And it is an unjustified gloss. And for that matter, reading in incorporation by reference to an immigration rule is also a gloss. As is reading in a subject to a gatekeeping executive function by the Secretary of State a gloss. And we say all of this because the statute gives a range of relevant anti-abuse powers. Clearly unfounded, out-of-country appeal. Should have been raised before, no right of appeal at all. And it's all summarised in our paragraph 3 and our paragraph 17. There are three topics in particular I want to go into. I want to look at the statute with you. I want to go back to Bingham. I want to then look at BA. Why that was anonymised, I don't know, because of looking at the way it was reported below. And I want to look at...
Well, we didn't start asking questions quite so frequently as we now do.
No.
about the need for
Quite.
anonymity.
But anyway, the days of these cases are called BA and ZA, which is going to be my next one, have gone, and then I will turn back to our statute and round the points together, but I've essentially made them already. Now, two things that are not, as we understand it, contested. The first is if we're right on the claim point, then we win. In other words, to say, I rejected it on its merits, but that's not a decision to refuse, is not a point that's taken. And you'll see it in Mr. Eadie's paragraph 70, where he deals with that very point and says, yes, but the point is, if you haven't got a claim, you can't have a decision to refuse a claim. And the second thing that, as we understand it, is not in issue, is that it's natural to speak of our clients' submissions, albeit that they'd been an earlier claim, as having been a claim. And why do we say it's natural? One of the reasons we say it's natural is because the decision letters themselves use that language. You have made a claim, we have considered your claim. And Sir James's answer, I'm really sorry if I said Mr. earlier, Sir James's answer to that is, well, yes, that's the language that you find in a decision letter describing what you've done, but there's a legal meaning of claim which you find later on, and it's the legal meaning that matters. That's his paragraph 69. Topic 1, the 2002 Act, Part 5. This is our paragraph 43. And we look at it as it is for the purposes of this case in Bundle 1, Tab 2, starting at 433. And Part 5 starts on page 491. And right the way through, as you know, Part 5, as the constant theme, is claims, protection claims, human rights claims. You find it in the heading to Part 5 at the top of 491. It goes all the way through and on and out the end to section 113 on page 522, which is the interpretation section for Part 5, which then, in the interpretation section, says what claim means. Top of 522. And you can find other references in other parts of the statute. So, for example, on page 529 in Part 6, you get it under section 120, which is the serving of a notice. And over the page in the middle of 530, you see that the definition relates back to Part 5 in 120 subsection 6. So we know from 113, the interpretation section, protection, human rights claim. Protection claim is middle of that page, 522, has the meaning in 82.2. But top of that page, asylum claim, human rights claim. A claim that to remove me would breach relevant obligations. Refugee Convention, Human Rights Act, and then added in to human rights claim in 2014, the words in square brackets, 522, the third defined term, or to refuse him entry into the United Kingdom. So I might be outside the United Kingdom and I'm claiming that to not let me come here is a breach of my human rights. For the purposes of our case, we can focus on removal, but it's right to draw your attention to that. Protection claim then takes us back to 82.2, and 82.2 is at the bottom of 491, top of 492, would breach the obligations, either Refugee Convention or now we've got subsidiary protection, so the expanded obligations of humanitarian protection. I claim that if you removed me, that would breach your relevant obligations of one of three kinds. Refugee Convention, extended asylum protection, humanitarian, Human Rights Act. And that's claim. And decides to refuse, is the language of 82.1 A and B, and Parliament added in 82.2B for protection claim. Protection claim is refused if you make a decision that removal would not breach. It's the substance. It's not technical, it's the substance. You decide, I say removal would, you say removal wouldn't. Two immediate clues, my ladies and my lords, from this statutory scheme. The first, section 82.2D on 492, the definition of humanitarian protection. What did Parliament do? They built in a reference to immigration rules for that purpose. Humanitarian protection is to be construed in accordance with the immigration rules. So, as we explain in paragraph 16.2 of our case, Parliament knows how to do that. That's a technique that is available. And if we just keep a finger in that, or if your electronic go to 522, back to 113, section 113, there's a definition of immigration rules, and I want to come back to this when we look at ZA. But in the middle of 522, immigration rules means rules under section 14 of the 1971 Act. I know it's very familiar, but there will be a point to make about it. The second clue that we already have, back at 492, page 492 in section 82, is subsection 3. The rights of appeal under subsection 1 is subject to the exceptions and limitations specified in this part. That's where you're looking for exceptions and limitations. And they might be provisions about whether you can appeal at all. Section 96 should have been raised before. Or they might be provisions about where you can appeal from. Section 94 with section 92, clearly unfounded. So, as we say in our paragraph 13, there are 4 basic stages here in a removal would breach case, whether it's human rights, humanitarian, or asylum. I claim that removal would breach. Secretary of State refuses my claim, decides that removal would not breach. C82.2b, but it would be the same for human rights. Third stage, I appeal on the ground in section 84.1 on page 493 that removal would breach the obligations, see section 84.1. And then the tribunal, first-tier tribunal, determines whether removal would breach. And that's section 86 on page 495. Any matter raised as a ground of appeal, 86.2a, and you can add in matters, but the matters you add in on the previous page, section 85, subsection 6, are themselves matters that constitute a ground of appeal of a kind listed in section 84. So it's all the same, the beautiful symmetry. Removal would breach all the way through. Yes or no. Section 94 then, I know it's all very familiar, therefore I remind you, page 499, the Secretary of State may certify 94.1 a protection claim, there it is, or a human rights claim as clearly unfounded. And this is a where provision. Where do I appeal from? That used to be a subsection 1 and a subsection 2, which were to identical effect, and Parliament merged them. Why is it a where provision? Because if you go back 2 pages, section 92, place from which an appeal may be brought or continued, we get section 92.2a. The claim to which the appeal relates has been certified. Claim to which the appeal relates. Again, a where provision. One of the things we get from Sir James and also from the Court of Appeal is, well, yes, in a where provision, Claim just has its natural meaning. It has its straightforward meaning, but it's different if you're in a weather provision, is what they say. Well, let's look at a weather provision. Section 96 is the other certification power, and this is the should have raised before, page 505. Earlier right of appeal. You were notified of an old decision, 505, halfway down, which had a right of appeal. Now, your claim, and here's the language, and this hasn't changed. The claim or application to which the new decision relates relies on a ground, that used to say matter, that could have been raised in an appeal against the old decision. So, and in the opinion of the Secretary of State or the immigration officer, there's no satisfactory reason, so no good reason for that. You could have raised it before, and you should have raised it before. And if that's the position, there is no right of appeal. So that is a whether you can appeal certification. It's part of the same code, in the same part of the same statute, using the same language. And that's not new. That's been there and was always there, and was there when the House of Lords decided BA. So these two things are side by side. They make sense. And to be clear, as Mr. Hussain was clear in his submissions at BA 448 letter F, bundle 1343, clearly unfounded will include the situation where it is merely duplicative. You raised this, it was dealt with, and it was determined against you. And as to the elusive distinction between no reasonable prospect and clearly unfounded, the House of Lords saw a difference between the two at ZT, but a very, very narrow one. Lord Neuberger, very rare that the result could be different.
But in 96(1)(b) is not dealing with claims which were brought previously, but ones which could have been brought previously.
No, I'm sorry, I hopped back to section 94, which is my mistake. What I'm saying is look at these two side by side. You've got a 94 certification, which goes out of country, and I'm just making the point that that will include ventilated previously. And my lady is right, section 96 wasn't raised, but should have been raised. So, and actually section 96 originally had a subsection 3, which did include this was raised before, and it was taken out. But how do they fit together? Well, look, if I am saying something that I haven't said before, but should have done, we don't have anything to go on. We can't point back to anything. It's enough to say, should have raised that before. If I did raise it before, we've got something to look at. And we can see, is it identical? Is it different? And that's something we say that squarely falls within section 94. So a range, a statutory code, a statutory definition, a coherent part 5, and a range of relevant powers. Now, just to add before I move on to my next topic, a few observations while we've still got the statute. We've got 3 categories here. We've got asylum, we've got subsidiary protection, so extended asylum, humanitarian, and we've got human rights. That alone tells us that a subsequent claim may be distinct, indeed very distinct. It may have gone from, I fear harm if returned, and somebody says, well, actually the harm doesn't reach the appropriate level of severity, to, I now have a family. I'm here and it will rupture my family life. And there are different classifications, and of course it's accepted that it's not just a question of, are you repeating? The Secretary of State may assess me as he assessed my client in this case. Well, yes, now you've had a baby, or the partner is pregnant, a different area. It's not that it's the same as you said before. It's that I assess that there's no reasonable prospect of that succeeding. And equally, you can have a situation where something happens after I've gone abroad. and the circumstances have changed. I might be in a different area, I might be in the same area but with a different sort of ground. And in those circumstances, it may also be said, yes, but this isn't a claim. And the reason it isn't a claim is not because it lacks distinctiveness. That's not enough. The reason it isn't a claim is because I say it doesn't have a realistic prospect of success. And on that basis, on the Secretary of State's case, I'm out in terms of being able to rely on this statutory scheme at all, because claim has the meaning that brings in Lord Bingham's acid test. So that's the first point to see while we've got the statute. Second point, just worth examining, perhaps, is section 92(4) on page 498. In the case of a section 82(1)(b) human rights claim appeal, where the claim, page 498, subsection 4, to which the appeal relates, was made while the appellant was outside the United Kingdom, the appeal must be brought from outside the United Kingdom. So Parliament is recognising that I can make a relevant claim with an out-of-country appeal. But if it's right that one interprets the whole of Part 5 to read in either a gatekeeping function or Sir Thomas Bingham's acid test from Onebayo, then the consequences would presumably be that actually, however distinct it is, and although I'm abroad while I'm making it, it's not actually a claim. And it's not actually a claim because of some previous claim, and not even because what I'm saying is the same, but because it's assessed that it doesn't have a realistic prospect of success. And that has a number of oddities to it, not least that the gatekeeping function doesn't even work in that situation, because Rule 353 of the immigration rules is inapplicable in a case where you're outside the United Kingdom. But by operation of the statute, it would be said you're out. You can't do it. It's not a claim. It's not a statutory claim. Presumably, it would be said then that it would be a jurisdictional question for the tribunal. First thing we have to say is whether we've got jurisdiction. We then have to look, has it got a realistic prospect of success? If you want to see that Rule 3 doesn't apply if you're outside the United Kingdom, it's at page 646 in the electronic bundle, and it's volume 1, tab 3 in the paper copies. Now, just to bring in this point, we make it at our paragraph 41. Appeal doesn't necessarily mean a hearing. There is a rule, and there has been for a very long time, as we explain in paragraph 41. It's Rule 43, which means the tribunal doesn't have to have a hearing. If I am abroad, and I don't have a legal representative, they don't have to have a hearing. Rule 43(1)(c), they can decide it on the papers. It's page 664 in the bundle, tab 4 of volume 1, Rule 43. Or if the tribunal is satisfied, having given people an opportunity to address it, if the tribunal is satisfied that it's not necessarily the interest of justice to have a hearing, then you don't have to have a hearing. So I think I said Rule 43, that was the original rule. It's now Rule 25. I do apologise, but it is on page 664, as I said. Must have a hearing except C, outside the United Kingdom doesn't have a rep, or G, considers it can justly determine the matter without a hearing, and then you've got to warn people if you're going to do that. And that, of course, if you did have well, this is just utter duplication. It's certified, you've got to go, or perhaps you're already out of the country. Do you have to have a hearing? No. You can dispose of it. Section 96, while we've still got it, is also worth just reflecting on. It was at page 505, and this is the certification that should have raised earlier. What's interesting about Section 96 is the whole essence of Section 96 is that you're in a repeat world. not repeat world, a further submissions world. Something has happened before, and you are making submissions now. That's exactly what Parliament is thinking about in Section 96, which again supports the straightforward application of claim. Claim includes submissions that are made subject to the safeguards that arise, including Section 96. Now, if I pointed out Section 120 a bit earlier, I'd like just to go back to that. It's in Part 6, but it borrows the same definition, and it's at page 529. And it gives the Secretary of State a power in Section 120, subsection 2 on page 529. Secretary of State or an immigration officer may serve a notice on P requiring P to provide a statement setting out reasons for wishing to enter or remain, any grounds on which it should be permitted, any grounds on which they shouldn't be removed. It's a flushing out notice. So ask this question. Could the Secretary of State serve a notice if someone is making subsequent submissions? Because there may or may not have been a notice at an earlier stage. Does that power on the face of it apply in a situation where, well, you've been making these submissions, you say previously it was asylum, but it wasn't found that there was sufficient severity back home. You now say family life. Well, that may be right. But the first thing I'm going to do is flush you out. Here's a notice. Say everything you've got to say so it can all be considered in the round. Our submission is on the face of it. Plainly, that power could be exercised in that situation. It wouldn't be fatal that at the very first stage of the very first decision, there hadn't been a Section 120 notice. And suppose one is served. Secretary of State serves a flushing out notice, gets all the material, then considers it in the round, says, you know what, I reject it. And not only that, but I don't think it's a real claim because it doesn't have a realistic prospect of success. That's my view, that's my assessment. What does that mean? The Section 120 notice is invalid? Does it mean subsequently it can't be pointed to? Well, you had a Section 120 notice and you were required to say things earlier. Answer no, because as a matter of Onibio acid test law, as subsequently assessed by you yourself, you said that didn't have a realistic prospect of success. The answer to all of these points is the same. It's very straightforward. You've seen the language, the three most important landing points for it. Section 94(1 may certify a protection or human rights claim. Section 92, the claim to which the appeal relates. Section 96, the claim to which the new decision relates. Why have I focused on them? Because the House of Lords had all of those when it considered BA. That's topic one. Topic two, back to Bingham. I'm going to call this the LinkedIn world, the world where the appeal you had something else in it than the four stages I've been describing. And just to describe them, and then we'll look at a couple of statutes and a passage in Sir Thomas Bingham and a passage in Mr. Justice Blake. Let's take human rights or asylum. It's the same for, I'm claiming that removal would breach. You're saying you don't think removal would breach. I'm appealing on the basis that it would. Tribunal is deciding whether or not it would. Something is added in, and what's added in is an immigration decision in the old world of the 1993 Act and then the 2002 Act prior to 2014. So what it comes to is this. I'm claiming that removal would breach, and I am asking you to take action. And it could be I'm asking you to give me leave to remain or leave to enter. Or it could be I'm asking you to revoke the deportation order that you've made against me. But that's the extra bit. That's the and. So the Secretary of State, if it's negative, comes back and says, removal wouldn't breach. So I'm reject your submissions. And having rejected your submissions, I'm now going to refuse you leave to enter or remain. I'm going to now refuse to revoke your deportation order. So that's the and, the action that is requested, the action that is declined. And if we go back to 1993, we can see it very clearly in the structure of the statute as it always was. It's in paper volume 2, tab 5. It's in the bundle electronically at 685. And this is the legislation that the Court of Appeal is considering in Onibayo and Kakabay. And if we just have a quick skim through it, page 686 in tab 5 of volume 2 is where you've got claim for asylum. These were just asylum appeals in section 93. Human rights appeals came in 99 in readiness for the Human Rights Act coming into force in 2000. Claim for asylum you get then at 686, very familiar, it's the same structure. And what you then get at section 8 is your appeal right, page 699. And it's not a person whose claim for asylum is refused. It's a person who is refused leave to enter under the 1971 Act may appeal, but then on the ground that his removal would breach. And so that's the way it's structured. And then you get the appeal. Similarly, refusal to revoke a deportation order, section 8.3b, where the Secretary of State has refused to revoke. So that's the and bit. And it's all set out in paragraph 39 of our case. Now, what did that mean? It meant there had to be a nexus, as we describe it, paragraph 21.4, between two things. Two things are happening, and they are linked. It's a linked-in appeal mechanism. The nexus is between the claim that is being made and rejected, if rejected, on the one hand, and the leave to enter or refusal to revoke.
Well, the immigration decision.
The immigration decision. So you'd have a refused claim, we say, plus an appealable immigration decision. That's the structure. Now, if we look at Lord Bingham, Sir Thomas Bingham as he was, in Onibayo at tab 7 of the same volume, at page 744, he makes this very point. Letter H, bottom of Law Report 782, our bundles 744. It's plain, says Sir Thomas Bingham at letter H, 744, from section 8 of the Act of 1993 that an appeal lies not against the refusal of asylum, but against a decision made or action taken or not taken pursuant to a refusal of asylum. And of course he goes on to formulate his acid test of what was to be understood as meant by claim for the purposes of the 1993 Act. But there is the nexus, and there is the both and, that you'll have made a claim, it will have been refused, and then an immigration decision will have been made. He says not taken because that's the refusal to revoke example. Pursuant to that refusal. And then, while we've got it, of course, we ought to remember the acid test itself at the bottom of 745 and the top of 746. And Sir Thomas Bingham always included in his acid test two components, top of 746. First, excluding material on which the claimant could reasonably have been expected to rely on an earlier claim. And then, second, the new claim is sufficiently different from the earlier claim to admit of a realistic prospect. So, realistic prospect through distinctiveness. And as we'll come on to see when I remind you, it's been recognised that the first part of that finds its analogue in section 96. And the second part of that finds its analogue in section 94.
Sorry, in?
Section 94. And not to keep you in suspense, that's Lord Brown, paragraph 46 in BA, which was a majority view. Because of the agreement of the others with him. Now, Sir James Eadie says at his paragraph 63.2, well, don't forget that there was a certification power at the time of the 1993 Act, so we mustn't. It's at page 723 in tab 5 in Schedule 2 to that statute. So James describes it as a certification power for the denial of appeal rights. It's worth just looking at it to see what it was. Page 723, Schedule 2, paragraph 5. The certificate is claim without foundation. The test at 5.3 is it either doesn't raise any issue at all under the Refugee Convention or is frivolous or vexatious, 5.3b, and then 5.5 tells you what the effect was. This was a second appeals certificate. You had your right of appeal to the special adjudicator, but if the special adjudicator agreed that it was frivolous or vexatious, you didn't have an onward appeal to the Immigration Appeal Tribunal. So that's 5.5. Now, in the LinkedIn world, as I've called it, of the 2002 Act, as it was prior to 2014, so here, this is the statute that we describe in our paragraph 43. That's the Act as it is found in Volume 3, Tab 15 in the paper. Page 1099 electronically, Part 5 starting at 1156. And what the 2002 Act Part 5 did at 1156 was it had a menu of immigration decisions, as you know, Section 82.2, 13 of them. They included refusal of leave to enter, that was A, and they included refusal to revoke a deportation order, that was K, on page 1157. So that's what you had to be appealing against. And there were then 7 grounds on which you could appeal in section 84 on page 1159, A to G. And they included decision not in accordance with the immigration rules, which was A, but they included unlawful under the Human Rights Act, section 6 is C, and then removal would breach was 84.1G. So that's the statutory scheme. If we just, though, strip it down and focus on the removal asylum human rights case under this statute as it then was, the 4 stages are these. I claim removal would breach, and I request the relevant action for the purposes of section 82. If I fail, then the Secretary of State rejects my claim, and the Secretary of State then has to deal with what about the requested action. And you might have a decision letter that says, and in the light of that, I refuse to revoke the deportation order. And you might have a decision that says, in the light of that, I refuse you leave to enter. That would be, in Sir Thomas Bingham's language, the refusal pursuant to the refusal of the claim. And that's the structure. So, gateway provision to get into an appeal, an immigration decision that you can appeal against and that you can point to.
In the old system, there used to be quite a lot of cases around where there was nothing to appeal until the removal decision was taken, didn't there?
Yes.
How did that happen? In your world, they're linked and they always have some action sought as a result of consideration of the substantive claim. So how did we end up with those cases where there was nothing to appeal until a removal direction was given?
Because the Secretary of State would say, I'm refusing your claim or rejecting your submissions, and I'm not making an immigration decision for the purposes of Section 84. That's how that would arise. So that's the old world, and I will show you, if there's time, the passage in Kakebe that deals with that very point. We're going to need to look at this because I'm going to need to look at ZA in the Court of Appeal, which is all about that very point. Then, under the statute, as it was, there were the range of provisions throughout Part 5, leading up to the interpretation provision of Section 113, including the statement in Section 120, all of which referred to claim and asylum claim and human rights claim. So, for example, just to take an example, Section 83 on page 1158. This section applies, 83, 1158, where a person has made an asylum claim, his claim has been rejected by the Secretary of State, but he's been granted leave to enter or remain for a period. So I've rejected it as the Secretary of State, but I've given a leave to enter or remain, and you can appeal. Why can you appeal? So the tribunal can decide the refugee status, because there are important benefits that come with being recognised as a refugee. That's why you get all those cases that came all the way up to the highest altitude, where the Secretary of State says, I'm not going to return you. And it's not the point. I need my refugee status decided. But what's quite interesting about that is the word rejected. And rejected is synonymous with refused. I can say that with confidence, because this is a provision that was later replaced by another provision, namely Section 82, and the explanatory notes tell us that he didn't need this provision because he's now got 82. But anyway, you can see it on its face. Claim rejected, but the and here is positive, but you can still appeal. And my submission throughout these provisions, claim means claim straightforwardly, whether or not the Secretary of State assesses it in any of those ways I gave you at the beginning of my oral submissions. Then we go to 84, we've seen the grounds of appeal. 86 is the determination. And 92, page 1166, is our where certification. And 96 at page 1172 and 1173 is our whether certification, should have raised it before. And the language is the same language that we've seen. And in particular, if you look at the bottom of 1166, this was actually the provision that BA was about. 92.4a. This section applies, so that means you can do it in country, because 92 takes you out of country unless this section applies, C92.1. And you're out for K, refusal to revoke, or refusal of leave to enter, C92.2, unless you're back in. Back in, if this section applies, 92.4 applies to an appeal against an immigration decision if the appellant has made an asylum claim or a human rights claim while in the United Kingdom. What did it mean? And that's what the House of Lords was grappling with, and they did three things. They said that does mean a claim, albeit that it's subsequent and the Secretary of State assesses that it has no realistic prospect of success. It is nevertheless still an asylum claim or a human rights claim. They also said Section 94 applies in that situation. 94.1, 1167. This section applies where the appellant has made an asylum claim or a human rights claim or both. 94.2, skip 1a, person may not bring an appeal if the Secretary of State, an appeal to which this section applies, in reliance on section 92(4)(a), if the Secretary of State certifies that the claim or claims mentioned in 1 is or are clearly unfounded. You could merge those, and Parliament did, and we've already seen it, because that's what happens when that provision is recast in 2014. But, House of Lords, that certification power applies to a claim even though the Secretary of State has assessed that it has no realistic prospect of success. And Section 96, the language that's now familiar on page 1173, claim to which the new decision relies on a matter that could have been raised. That claim to which the new decision relates is a claim notwithstanding that it's assessed as having no realistic prospect of success. And that is a whether provision, not a where provision. And that's how the code works, and that's how it fits together. Now, I promised a Mr. Justice Blake reference just on the point about nexus, because it's quite interesting, important to see what had been cleared out of the way by the time BA got to the House of Lords. If you look at tab 18 in volume 3, 1306 in the bundle, we can see from the headnote when the BA case started that the first thing that Mr. Justice Blake decided at letter G on page 1306 was that the words "has made a claim" in 92(4)(a) mean that an in-country right of appeal will only exist where there is a nexus between the immigration decision which formally generated the appeal and the representations or application that the immigration decision had been responding to. So that's why I've emphasised and shown you it, 1993 Act and Sir Thomas Bingham. I've now shown you it in the 2002 Act and Mr. Justice Blake, that you've got to have a link between two things that are happening. One is the claim that is being rejected, and the other is the immigration decision that is linked to that. In other words, it's not enough that there's been some historic and decoupled asylum or human rights claim. So that's the point that he makes. If you want to see it in the judgment, it's at 1316 in paragraph 43. And by the time BA had got to the Court of Appeal, it was a non-issue. In fact, leave to appeal had been refused on that aspect. And that's at letter E on page 1328, where in the submissions it's accepted that the appealable immigration decision, letter E on 1328, must be in response to or otherwise connected with an asylum or human rights claim. And the Court of Appeal, it was Lord Justice Sedley at 1332, at letters D to E, on that page 1332, records it. There has to be a nexus between the immigration decision against which the appeal was directed and the content of the initial claim for protection, and permission to appeal had been refused to say otherwise. So that's why we emphasise that at 21.4, all of which then was the backcloth to the House of Lords, both claimants having had their immigration decision because the Secretary of State had been asked to and had refused to revoke the deportation order. So they're in this appeal world, and I therefore move to my next topic, which is let's look back at BA Nigeria in the Supreme Court. Tab 20, volume 3, page 1339. I've already told you what it comes to, and I've already told you the three important locations. We've summarised all of this, and if I can cut through it in this way, it's all set out on the page in our paragraphs 22 and 23. But what they say, with a dissent by my Lady Hale, is that the ordinary natural meaning of the word should be applied. That is to say, don't gloss the statute. And it would be a gloss to invoke the Bennian principle of taking Sir Thomas Bingham's meaning of acid test and implying it into the statute. And why did they so conclude? It's all set out in 22 and 23 of our case. There's a range of powers that deal with this situation, and therefore they are necessarily applicable to this situation. Section 94 applies, notwithstanding no realistic prospect of success in the Secretary of State's assessment. Section 96 applies. So 94 you can certify and it's an out-of-country appeal. 96 you can certify if you've got nothing to point to from before, but that's the whole point, because it should have been raised before by the individual. So the components, if we look at Lord Hope, in paragraph 14 on page 1349, you'll find the appealable immigration decision at letter F. So that's the starting point. At paragraph 24, you'll find at letter F the argument based on Onibio. It was Onibio plus Bennian statute is to be read as incorporating the meaning that it's been given in previous case law. So that's Sir Thomas Bingham's acid test. And you see that very clearly at 1353 letters D and E, where D starts with Bennian, the informed interpretation view, and therefore adopt Sir Thomas Bingham in Onibio is the argument. So that's the second component. It's an Onibio and Bennian submission. How does he deal with it? 27 and on. He deals with it by reference to this statutory scheme, Part 5. And he deals with it by reference to the scheme as a whole and the range of powers, and in particular, safeguards against abuse. It's plain, he says, the scheme is not the same as Thomas Bingham has. Yes, there was a certification. We've seen what it was. It was a second appeal certification. The problem to which he was addressing was created by the absence of any provision to prevent abuse. 28, Parliament could have left the matter to be dealt with under the immigration rules. That's a rather prescient point in the light of Section 12, never brought into effect. It has not stood still. Provisions against abuse, starting in 1999. And then what are they? It's 94 and it's 96. And you get all of that at paragraph 29, the range of powers. And it's not just the where provision in section 94, it is explicitly the whether provision in section 96. If you look just below letter B, the power in section 96 enables the Secretary of State. So those are powers, those are safeguards, those are applicable, and then you get the conclusion just below C, don't gloss the statute. Can only be read into the Act by, as Lord Justice said in the Court of Appeal put it, glossing the meaning of the words a claim, so as to exclude a further claim which has not been held under Rule 353 to be a fresh claim. That's the issue in this case. It's exactly the way it's put. How's it put? It's put on the basis of Bennian. It's put on the basis of Onibio. And here it is rejected because of the range of powers which are held to be applicable. And then he goes on to make a point about disparity. Disparity in the situation where someone who starts with an appeal right then finds they can't operate it from abroad because it's frustrated by the impact of the language of section 94.9 of the statute. That's what he's doing when he deals then with paragraphs 30 and 31 and the beginning of 32. And then at the end of 32 at letter C, I would hold. Claims which are not certified under 94 or excluded under 96, if rejected, should be allowed to proceed to appeal in country under 82 and 92, whether or not they're accepted by the Secretary of State as fresh claims. And again, crystal clear. 94 and 96 are applicable to a claim, notwithstanding that it hasn't been accepted by the Secretary of State as being a fresh claim. And he then goes on to refer to ZT Kosovo, which I'll come back to in my submissions. And he says this is a code in which Rule 353, as presently drafted, has no part to play in the scheme, just above letter E. And of course, that led to some head scratching that I will need to address, and I will address in ZA. Now, all of this was in full recognition that he was talking about claim in Part 5. See paragraph 2. The relevant provisions, letter C, page 1345, are to be found in Part 5. And of course he recognised that he was dealing with a statute which defined asylum claim or human rights claim in section 113. That's the point he makes on page 1348 at letter G in paragraph 12. So the question is answered, it's answered straightforwardly. This would be a gloss, unwarranted gloss. You've got powers. Those powers are applicable, notwithstanding that you've given a negative classification. Not only have you rejected the human rights or asylum claim, you have gone on to say, I've assessed this as not having a realistic prospect of success. Lord Roger agrees. Lord Scott, on page 1355, first at letter G, agreeing with Lord Hope and Lord Brown. I will look at Lord Brown in a moment. Lord Roger, just below at 1355 at the bottom, agreeing with Lord Hope and Lord Brown. And Lord Roger again explaining it's the meaning of asylum claim in section 92.4a. Just fingering that and going back to the way the issue is described by Lord Hope, it's page 1345 between letters C and D at paragraph 2. The question is whether the expression an asylum claim or human rights claim in 92.4a includes a second or subsequent claim, only if it's been accepted as a fresh claim. That's the question that they answered. Lord Roger, again, is referring to it at 37 on 1355, and he says, at the top of the next page, given the new scheme, this is his final sentence, there is no longer the same need to adopt the full interpretation. Indeed, the one now adopted fits the new context better. What's the new scheme that doesn't need it? It's the scheme with the powers that are applicable in terms of the dual certification. Lord Brown, I'll come back to Baroness Hell. Lord Brown is at the bottom of 1357, starts with the Onibio point and at letter H. Statutory solution to the problem of abuse lies not in construing asylum claim in accordance with Onibio, but rather, top of the next page, the Secretary of State issuing certificates where appropriate under 94 or 96. So again, couldn't be clearer. 94 and 96 apply in this situation and provide the answer. And this is the statutory interpretation. And just on the abuse argument, which you have heard and will hear, if you look at 1342 at letter H, you'll see it's the same to the House of Lords in BA Nigeria, just above letter H. If the Court of Appeal's decision stands, the removal will become difficult. They can always ask for the deportation order to be revoked, and they'll be able to stay by the simple expedience of raising a new argument, however thin or repetitious. That's the case for the Secretary of State. That's the abuse that Lord Brown is addressing in paragraph 44. And then he deals with a rather interesting issue about why it was being said that you couldn't certify in BA. And as he points out at paragraph 45, the only reason what that was the Secretary of State's position was because of her position on claim. She wasn't saying, if I'm wrong, I can't certify. She was saying, I can't certify because I'm right. So, as I understand it, he says at letter B, that's solely because of the language on the Secretary of State's argument. But given, he says at letter C, as counsel had submitted, and I would accept, a repeat claim does involve making a claim for the purposes of 92.4a. So too it enables the Secretary of State to certify. So you could certify. There was no bar or block to it if it was clearly unfounded. And he then makes the point that I had made about half an hour ago. It's a very elusive distinction. As Lord Neuberger had pointed out, there will be precious few cases. I think he says in another passage in ZT, you can just about intellectually imagine it, but in practice it's very, very difficult to see. Precious few cases in which that test differs from realistic prospect of success. The major reason I'm persuaded is because Parliament has made express provision to deal with abusive claims, letter E. And then I promised you this on Sir Thomas Bingham's two components of his acid test, just above letter G. I hope the court will find, excluding material, having set out Sir Thomas Bingham's test, excluding material on which the claimant could reasonably have been expected to rely on his earlier claim, is now expressly dealt with by section 96. Another reason why it doesn't work to say incorporate a test from a 1986 or 85 judgment of the Court of Appeal. Part of that's been dealt with in one way, and then he says, as already explained, ordinary repeat claims fall to be excluded under 94. And then he adds a point about the parity that it means, where you can put people in the same position where they both have an out-of-country appeal. My Lady Hale dissents. She accepted the Onibio and Bennion argument. My lady made clear it wasn't read in an immigration rule. It was adopt an interpretation from a previous case. And you see it on 1356 at letter D, the well-known principle of statutory interpretation. And you see it specifically at the bottom of that page. The argument is simply that when they enacted this section, they already had that well in mind. She, that's counsel for the Secretary of State, is not relying on Rule 353 to construe the Act. Same in this case. Sir James isn't saying construe this in the light of the rule. He's saying construe it in the light of a line of authority that adopts a particular approach. And then if I may respectfully submit, the point that one finds on the next page as the recurrent theme is about repeat claims. And it's about repeat claims in the context where my lady was concerned about certifiability. Letter B, apparently it's not suggested that the fact that a claim's been made previously and rejected necessarily means that it's clearly unfounded. And you just said just before that it's common ground that neither of these claims would have been certifiable. That, in my submission, is the point that Lord Brown then answers, because the problem with wouldn't certify came from the Secretary of State's interpretation of the statute, which the court was rejecting. But the repetitious claims point is at letter C, section 96. This was the point put to me by my Lady Arden earlier this morning. Doesn't deal with a claim that raises exactly the same matters. And that's right. I've dealt with that. You'd have to certify under 94. I don't accept the next bit, that new powers are not apt to cater for repetitious claims. But my point is that this dissenting judgment is concerned with repetitious claims. If you look at letter E, essentially the same claim has already been determined. No reason to give someone in that position a second bite at the cherry. And then same thing between F and G, essentially the same claim, time and again, as a way of staving off their departure. And so the answer that I give to that is that in that situation, that would be certifiable under section 94. the only reason the Secretary of State was saying otherwise was because of her interpretation of the statute, which the court rejected. That's what Lord Brown found. He had the rest of the court agreeing with him, as we saw. But just so you can see, this isn't in some way some afterthought. Mr. Hussain, in his submissions reported in the law reports at 1343 letter F, makes that point. Repeat claim. Repeat of an unsuccessful claim will be clearly unfounded even if the first claim was not. And of course, it's a well-established principle. If I've been through an appeal and I've had a determination against me, then that's where the tribunal starts. And you need a very, very good reason. And you certainly wouldn't have a very, very good reason. You wouldn't have any reason if nothing had changed at all. You were simply making a repeat claim. That's topic 3. Topic 4. Let's go back to the question my Lady Black was asking about. And this is the linked-in question about the immigration decision and the non-decision, whether it's leave to enter or whether it's revocation of a deportation order. And if we step back, you can see what's coming, and then we'll look at what came. Given that under this statute as it was, we've just looked at it, at the time of BA, you do need 2 things, not 1. You need your asylum or human rights claim, which will have been dealt with, and the Secretary of State rejects it. That's why you're appealing, because you're in a negative decision, or possibly an asylum case with a positive decision, but it's not enough to decide your status. Given that you need both of those things to mount your appeal, given that both of the appellants in BA had both, because they had both said, one of them was asylum, one of them was human rights, here are my further submissions. I claim that to remove me would breach the relevant obligations. Secretary of State says, I reject that. Secretary of State then says, and in those circumstances, I refuse to revoke the deportation order. Now, Miss Leng's, as she was submissions to the House of Lords, we just saw them, was that's going to happen. If you ask for a deportation order to be revoked and you're putting forward submissions, we deal with them on their merits. That will happen. Whatever happens about the assessing of the claim as not having a realistic prospect of success. But anyway, in any event, that's what happened in BA. It wasn't, I don't think removal would breach. I therefore reject your submissions, and I'm not going to do anything about revocation of the deportation order. Decision letters say I decline to revoke the deportation order. And ironically, in our case, that's what our decision letters say. It doesn't go anywhere in this case because it's no longer within the architecture of the statute that refusal to revoke is the target, the decision that you appeal. But given all of that, could Rule 353 of the immigration rules still have a role in the pocket of the extra bit? The extra bit, and will you give me leave to enter? The extra bit, and will you please revoke the deportation order? So 2 things are going on. What to do about the asylum claim or the human rights claim. What to do about the immigration decision. Whether to grant, whether to refuse, or whether to do something else. Could the immigration rules have a role in relation to the extra bit that you need in order to be able to appeal under the 2002 Act? Because it can go to the immigration decision. And the easiest way to see it is refusal of leave to enter. So, Secretary of State says, you've made submissions that removal would breach. I have decided that you are wrong. Removal would not breach. Now, what to do about leave to enter is a decision for me to deal with under my immigration powers. And I have rules that circumscribe leave to enter. So I look to those rules, and if those rules tell me that I don't even need to make a decision, then that's what I'll do. I will tell you, you've failed. I'm not refusing you leave to enter. I'm just not making an immigration decision. And that part of it is informed by my immigration rules, because I'm allowed to have immigration rules that deal with leave to enter. The counter.
Mr. Fordham,
yes.
I'm sure it's my fault. Whether there was an immigration decision following upon a substantive refusal was obviously very important once. But the threshold for an appeal against an immigration decision, as I understand it, been removed now.
Yes.
And so why are we looking so carefully at this nexus?
Because I want to explain ZA. But if you want me to leave it, I'm happy to leave it. This is what ZA is all about. And perhaps I'll do it as lightly as I dare, and then see if you want more help in reply. But it is the point my Lady Black put to me. My answer to it is the answer you've just put to me. That the 2002 Act, as simplified in 2040, this just doesn't arise. It's made very straightforward.
Well, for my part, Mr. Fordham, I'd be grateful to hear you on the point.
Well, different members of the court may provisionally be in different positions, so I will press on. I hope I'm all right so far for time. I'm racing in the light of what my Lady Hale said.
But I would like some assistance with ZA.
About, this case can't possibly take a day. So, but that's still in my mind. Let's dig a bit deeper. First of all, just to remember, we saw that section 113 at page 522 defined the immigration rules as rules under section 1.4 of the 1971 Act. And the reason why the statute needs to do that at page 522 is because the statute has incorporated, for the purposes of defining humanitarian protection only, the immigration rules. Now, let me just go back to very basics, and I know you all know this, but I'm going to risk it anyway. If we go back to Bugday, right back in the mists of time and the beginnings of anxious scrutiny at tab 30 in volume 5, I'll just remind you of the basic lie of the land at page 1751 in tab 30. And it's Lord Templeman. And we didn't give you everything, so we didn't give you the 1971 Act, but I can make the point by reference to this passage. If you look at 1751E to G, Lord Templeman tells us in Bugday K, page 1751, in tab 30, volume 5, section 1.1, the Immigration Act deals with right of abode, those who can come in without let or hindrance, etc. Section 3.1, I'm at letter F on 1751, shall not enter the United Kingdom unless given leave to do so in accordance with this Act. And then the power to give leave. And then at letter G, by section 3.2, the Secretary of State shall from time to time lay before Parliament statements of the rules laid down by him as to the practice to be followed in the administration of the Act for regulating the entry into and stay in the United Kingdom of persons required to have leave to enter. That's the statutory context for a leave to enter decision. And by statute, you look at immigration rules, because Parliament said so in 1971. And if you want the Act at any time in the chronology, please say it, and we'll happily provide it. This is one of those rare cases where actually the bundles are quite manageable. Rare immigration cases. What does ZA decide? We deal with it at paragraph 46. And it's a Court of Appeal case, as you know. What ZA decides will
Well,
look...
where do we find it? Because we can then
Yes.
look at it while we're listening.
Very well, let's do that. Let's do it in one go. It's in volume 4. I don't know if you noticed, but we kept the legislation with the cases.
Yes,
It's a bit of a challenge to know whether that was the best way of doing it, but
I think it was a very good
yes,
way of doing it.
was.
I'm really glad that you think that, because we agonised over that. ZA then is at tab 23 in volume 4, and you know that when you pick up ZA, you'll also have the High Court decision in ZA and the statute as it stood at the relevant time. And what...
Page number?
It's at 1427.
Thank you.
It's an interesting judgment for many reasons, the judgment of Lord Neuberger, but not least among them is the fact that what he does at 1437 is analysis in the absence of recent binding authority. Fine, no problem with that at all. 1437 at letter C. And there are, then, if you look very closely, the next headings have little indents where they are under that discussion. And so there's a little indent at E on 1438. And then you get the recent authority when you lose the indent in the heading at the top of 1441 and 1442 at E for BA Nigeria. And then Lord Neuberger's actual analysis, having looked at the issues in the light of the authorities, is at letter E on 1445 under discussion. So although it's rather odd to go straight to the end, in fact, that's the only safe place you can go to see what he's actually decided. And it's under discussion. So there we are in relation to that. And for that reason, I will go back, I promise, to see what he said previously. But if you go straight, please, to 1447 at letter H, he says in paragraph 59 in the second sentence, I've reached the conclusion, and he's considered BA and all the other matters, at any rate in this court, at the Court of Appeal level, that BA should be read as being confined to cases where there is an appealable immigration decision. Once there is such a decision, the complete code contained in the legislative scheme applies, and Rule 353 has no part to play. I adopt and embrace that conclusion. It's exactly right. You've got an appealable immigration decision because at the time of BA you needed one. You then ask the question, what for the purposes of Part 5 is the significance of the fact that it's been assessed as not having a realistic prospect of success? Answer, no significance. Under the statutory scheme, under the code, claim's a claim's a claim, whether or not it has any of those other characteristics, and the safeguards apply. And Rule 353 has no part to play. He then says, bottom of the page, as decided in ZT, Rule 353 still has a part to play. The Secretary of State can decide that the further submissions are not a fresh claim, in which case one does not enter the territory governed by the complete code of the legislative scheme. Right, what does that mean? What that means in our submission is that there can be a role for Rule 353, says the Court of Appeal, on the immigration decision part, and in particular, decision to refuse leave to enter. And I have explained by reference to Bugdake how you'd get there. Because you can look to the immigration rules, because the immigration rules regulate leave to enter, and you've got to decide whether leave to enter. So if you had a rule that said you don't need to make a decision in certain circumstances, here's what I'm going to do. I'm making a non-decision. Don't enter the territory of Part 5. The complete code doesn't apply. What cannot be right and cannot have been intended, and if it was what was intended and what is what's said, it's wrong in our submission, is that actually you can subvert BA completely through a gatekeeping role that says no one ever gets in. I'm never going to make an appealable decision. That would have the consequence that Section 94 would never apply. It would have the consequence that Section 96 would never apply, because the Secretary of State would say, yes, you've got a claim, yes, I'm going to reject it, but you know what, the next thing I'm going to do is tell you there is no decision here. I'm not going to refuse to revoke the deportation order. I'm not going to do anything. That would be startling, because that would immediately subvert what he said in the previous part of the same paragraph. Once there is a decision, the complete code applies and Rule 353 has no part to play. That's it. That's what ZA is about, and that's what ZA decides. And if we just take that back, to back that up, if we go back to the discussion section at 1445, like the Administrative Court, I've not found it entirely easy to resolve the issue. Is there still a role? As the Secretary of State argues, Rule 353 has no part to play where there's been an appealable immigration decision, and the only issue is whether the appeal is of a kind to which Section 92 applies. So just pausing there, you are in a world where there will be a relevant question, you are asking where the appeal is going to be from, and you're applying the straightforward meaning, unglossed.
But surely there can only be an appealable immigration decision if there's been a claim. And so if Rule 353 applies until that stage, then it has a role, does it not, in deciding whether there's a claim?
He's saying there can be cases where it does, but once you've got an appealable decision,
yes,
notwithstanding it's assessed as not having a realistic prospect, then you use 94, you use 96. He's not saying it's game over for certification powers. It's game over for whether you've got appeal. So he's contemplating, and this was a leave to enter case, that you could decline leave to enter. Now, I'll leave it to Sir James to go back to earlier discussion, save to say this. First of all, at letter F on page 1438, it's very revealing in his discussion of the interrelationship between the rule and the act at letter F on page 1438, that he's saying if Rule 353 can be relied on, the Secretary of State can decide it's not a fresh claim and then decline to make a decision on whether or not to refuse leave to enter, etc. That's why I say it's in the pocket of the immigration decision part of the map.
Mr. Fordham, the whole thing starts with there being a claim. Now, you don't accept that the Secretary of State is a gatekeeper in that regard.
Correct.
Who decides then, on your analysis, whether there is a claim? And what does a claim mean? You said 10 minutes ago, a claim is a claim is a claim.
Yeah.
I don't know how helpful you thought that was. Then you said a straightforward claim.
Yeah.
Well, is the notion of a claim as straightforward as you are suggesting?
In my submission, if I make the submission to the Secretary of State that to remove me would breach the relevant obligations, I am making a claim. The only formality...
What if you said that in March, and then in May you want to say, I want to add to that, there's another facet here, my girlfriend is pregnant. And then in October, you write another letter saying, we've now had a baby. And then in December, you write another letter saying, my girlfriend is very ill, I've got to care for her. You're adding the whole time. New points.
Yes.
They're not repetitious.
No.
They're new points.
Yes.
Are these new claims
Yes.
made in May and October and December?
Yes. And the Secretary of State has always accepted and still does that in all of those examples, there's no formality that relates to the obligation to give due consideration. All of those examples and any other If in substance I am raising the point that removal would breach, it is considered. Why is it considered? Well, we say because it's a claim. I was going to say the only formality in the statute was a locational, designated place. There's never been a designated place.
Is it a second claim, a third claim, a fourth claim? Or are these points that are being added to the original claim? I don't think this is straightforward.
No. In my submission, it doesn't matter. There's no consequence of that characterisation because the Secretary of State has before him a claim that removal would breach. If you ask the question, am I dealing with a claim? The answer would be yes. If you ask the question, was that latest letter a claim? My submission is the answer is also yes. I also submit that this must have been the way that the Supreme Court saw it in BA because they didn't conclude that there was any particular line or magic or formality to be drawn. And it would only matter if you could identify where does it go? What is that distinction informing? And the answer is nothing. Because it has to be considered. That's accepted. Those submissions have to be dealt with. They have to be dealt with on their merits. And a decision has to be made about them. That's the way I put it. I'm sorry if earlier I glossed myself over something that's okay. It's a difficult point. But my submission is... I won't say it's straightforward. My submission is that all of the examples that you've put to me would constitute claims.
I see. Thank you.
But in the end, it matters, doesn't it? Because Rule 353, if applied to something adversely to the claimant, leads to no appeal, and clearly unfounded leads to an appeal out of country.
It matters if the rule applies under the immigration rules.
Well, at the moment, we're trying to work out whether it applies.
Right.
And the consequence is different, I should have put it that way.
Yes. But
depending on whether it does or it doesn't.
That's correct, but in my submission, that's not because of any magic about what constitutes, or it's not because of any magic about whether in principle a new letter can be a claim.
No, I understand that entirely, but I'm just trying to see what, following it through to its...
That's certainly right. I just wanted to show you a couple of other things in this. So I've shown you, interesting, that it's the refusal of leave to enter that Lord Neuberger is emphasising at F. And he's then referring to Kakebye, which I will show you, Lord Justice Sheeman, as he then was. The other thing I wanted to particularly show the court, if I may, is paragraph 41 on page 1443. This is in the discussion of BA Nigeria. In each of the two cases, says Lord Neuberger, in agreement with the Court of Appeal, majority of the Supreme Court, Baroness Held dissenting, held it was not open to the Secretary of State to rely on 353. It is thus clear that in the BA Nigeria case, the Supreme Court decided that where the Secretary of State receives further submissions on which she proceeds to make an immigration decision within Section 82, there will be an in-country right of appeal under 92.4. Unless the Secretary of State certified under 94.2 or 96, it is not then open to the Secretary of State to invoke 353 to contend that the submissions didn't amount to a claim. I'll pause there. So that is a recognition that in the statute, claim is a claim notwithstanding that it's been assessed as having no reasonable prospect of success. It is a recognition that Section 94 was applicable to such a claim, and it's a recognition that Section 96 is applicable to such a claim. Confession time. I have struggled with the next sentence. So once further submissions are treated as amounting to a claim, and the claim is decided by the Secretary of State, the statutory code contained in the 2002 Act leaves no room for Rule 353. But the whole point is that the situation in which the statutory code leaves no room for 353 is in a situation where you've characterised it as not having a realistic prospect of success.
Isn't the emphasis on, in the penultimate sentence on the word then, if the Secretary of State decides to treat it as a claim and make a decision, then the statutory code is triggered. But if the Secretary of State interposes a Rule 353 determination, then it goes down the other path.
I wouldn't accept if the Secretary of State chooses to treat it as a claim. And the reason for that is that in BA itself, the Secretary of State had chosen not to treat them as claims. And that was the very scenario in which the House of Lords then decided, yeah, but you made an immigration decision, and in those circumstances you can't rely on 353. So it cannot be the premise for the BA analysis that the Secretary of State has chosen not to declassify under Rule 353, because in BA itself, the Secretary of State did decide to declassify under 353, and that's why the last sentence is so problematic. What is right is that once you have something that is a claim under the statute, and the statute is straightforward, there is no gloss, and you have an appealable decision, then there's no room for 353. Now, just to dig even deeper, and there are lots of clues throughout ZA. For example, there are points that were paragraph 30, where Lord Neuberger, without authority, says at 1440, certification doesn't apply if it's a declassified claim. Letter F, page 1440. But he's saying that before he's looked at the authorities. And we know that Section 94 does apply, and later on he accepts it applies. So handle with care. But where you get to is that ZA said Rule 353 could have a role as to whether the Secretary of State makes the immigration decision to refuse leave to enter. If we go back to Kakebe, I've nearly finished on this topic, but some of you wanted it and some of you didn't, or didn't as much. If I just ask you back to Kakebe and back to the 1990s, Kakebe is volume 2 at tab 9. This was Lord Justice Sheeman's judgment, the one that Lord Neuberger was citing. And there's a discussion about categorisation and fresh claim at 762. And this, of course, is in the Bingham world, the Onibayo world, where it's therefore not a claim under the 1993 Act. But the passage I wanted to show you is at the top of 763, just so you can see the two parts of this. First complete paragraph. In the case of a repetitious claim, no more is required to be done. The first decision has ensured you complied with its obligations. Section 6 creates no inhibition on the claimant's removals. That's all to do with the interpretation of the statutory scheme. Then this. So far as the decision on the claimant's repetitious application for leave to enter is concerned, the claimant will be told that leave has already been refused and there's no need for any new decision. And that's the point that I was making in response to my Lady Black's question early on. Were there situations where the Secretary of State said, you know what, I've looked at this and I'm not going to make a decision refusing leave to enter. I already refused you leave to enter. I'm allowed to do that because these are my immigration rules under the 1971 Act. And that's the immigration decision part of it. Which we say is the only possible, acceptable explanation for the Court of Appeal's decision in ZA. And just to push that home, if you go to the Divisional Court in ZA at tab 22, in volume 4, it starts at 1404. If you start at paragraph 9, on the top of 1407, you'll find a submission by the counsel for the Secretary of State. The Secretary of State, through counsel at top of 1407, contends that Section 92.4 of the 2002 Act does not give the present claimants the right of appeal because although they may have made a human rights claim, the Secretary of State has not made an appealable immigration decision and is not obliged to do so. That's the part of it. That's why it's in the pocket of the immigration decision part of the legal map. And if you just flick over, 1408, bottom of the page, is Lord Justice Sheeman in Kakabe, the very passage I just showed you, no need for a new decision, 1408 at the bottom. Paragraph 14 is then, the submission is the Secretary of State is not obliged to make an appealable immigration decision. So put aside claim and refusal of claim, we've got BA, we know about all of that. I still don't have to make an immigration decision if it's leave to enter, paragraph 14, and then you get the same thing at the end of 17 on 1410, and the punchline is in the middle of 1414, page 1414, at the end of paragraph 32. This was the divisional court. It's in the last 5 lines. Rule 353 has no part to play in determining whether a renewed submission is an asylum claim or a human rights claim, which is what BA Nigeria decided. It does have a part to play in determining whether the Secretary of State should make an appealable immigration decision consequent on the renewed submission. If I come back to my Lord Wilson's point, where you were ahead of me, on the statute as it is currently framed, as amended in 2014, the add-on has been taken away. It's not about an immigration decision. It's only about a claim which is refused. So the bit that was resolved and settled, as the divisional court recognised, upheld by the Court of Appeal, nothing inconsistent with that in our submission in the Court of Appeal, and if there was, it's wrong. That's what brings us back home, and I therefore turn to my final topic, which is to round it. As we explain in our paragraph 35.8 and 47, the 2014 Act then simplifies. It simplifies the world because the menu of 13 immigration decisions goes, as does the list of 8 grounds on which you can appeal go. In other words, the additional element of what do I do about leave to enter and these are my immigration rules goes. It is simply the claim, the decision to refuse the claim, and then the certification powers. It is my original 4 stages before they got complicated by LinkedIn provisions. I claim removal would breach. You decide whether you agree removal would breach. I appeal because removal would breach. The tribunal determines whether removal would breach. What does Mr. James say in attacking that analysis? Well, one of the things he says is, well, maybe it's different for where provisions and whether provisions. And the answer to that is it can't possibly be. They're all linked. There has to be a coherent approach to Part 5. And anyway, Section 96, which the Supreme Court was concerned with and specifically held was applicable, is a weather provision. It really can't make sense that the certification, which is about clearly unfounded, applies to one, and the certification about should have raised previously applies to another. He says we're not glossing the statute. This is just the real meaning of claim. Well, it is a gloss, because it's exactly the same gloss that Lord Hope described as a gloss in BA at paragraph 29. So James says, well, this is the settled meaning going right the way back to Onibayo of what claim means. Well, not quite so settled. It wasn't the meaning under the 2002 Act as held by the Supreme Court in BA Nigeria. But that's Ms. Leng's argument, as it was, to the Supreme Court. Settled meaning, Sir Thomas Bingham had this right from the start. The statute has used that meaning of claim. No, Lord Hope, paragraph 27, Lord Roger and Lord Brown, and then says the Secretary of State there's abuse. And the Secretary of State's argument on abuse is exactly the argument that I showed you from BA Nigeria. in that passage in the law report. And the answer is the same answer that the Supreme Court gave. Range of powers are applicable. They deal with the two aspects of Sir Thomas Bingham's test. If it is clearly unfounded, you must leave the country before you can appeal. Doesn't mean there'll necessarily be a hearing. That deals fairly and with parity between the two people in this world, one of whom never had an asylum basis, but did have a family life one, and you think it's clearly unfounded, and the second of which did have an asylum basis, which was rejected, but now has a family life basis, which, yes, it is distinct, but you say it doesn't have a realistic prospect of success. They are very, very closely similar formulations. Why on earth should one be in the position that they get an appeal, albeit out of country, not necessarily with a hearing?
I've been thinking back to the rules that I had to apply for granting permission to appeal to the Court of Appeal. I think the rules have changed, Mr. Fordham.
Yes, my lord.
But at all events, it doesn't affect my point, which is, first of all, is there a realistic prospect of success? No. Then, am I going to certify this as manifestly without reasonable foundation, i.e., really, clearly unfounded? Difficult, very difficult. You certainly didn't go on from the one to the other because you realized there was a big difference between them.
Yes.
But you're saying there's only a sliver of difference between them.
Yes, and it's Lord Phillips in ZT at paragraph 18 on 1079, Lord Neuberger in ZT at paragraph 81 and 89, which is 1098, and also Lord Hope in the same case at 46, Lord Carswell at 62, Lord Brown at 73.
Well, it looks as if I'm outvoted.
Well, the totally without merit is a very high threshold. And cases are certified as totally without merit throughout the legal system, including in the administrative court. It means you can't renew orally, you have to go to the Court of Appeal. My submission is that there is a very close link between no realistic prospect and clearly unfounded. If the certificate had been in the old formulation that we saw in 1993, where it was frivolous or vexatious, it might be a different position. But I'm not here to argue for daylight between those two. It's enough for me to put forward the views of the Supreme Court, at least I hope it is.
Thank you.
So he says abuse. Our answer is the same answer that was given Lord Hope 28-29, Lord Roger 37, Lord Brown 44-46. What about the Court of Appeal? Court of Appeal said it would be absurd. We deal with this at paragraph 34. It's really the same point. It would allow abuse. The Court of Appeal says section 82(1)(b) claim means original claim or fresh claim falling within Rule 353. That's paragraph 55. That, with respect, is the approach that even the dissent in BA would not have accepted, because it's interpreting by reference to the rule. But it is very clearly precisely the gloss. In fact, it's even worse because it brings in a gatekeeping function. It's also attributing to sections of the statute something that Parliament can perfectly well do. Humanitarian protection is defined as what the immigration rules say is humanitarian protection. The Court of Appeal also says at paragraph 54, well, BA applies to where provisions, not whether provisions. I've dealt with that. That's not correct. BA was concerned with both section 96 and section 94, but it's not coherent to start chopping and changing within an integrated set of statutory provisions between one and the other. The Court of Appeal says at paragraph 53, well, ZA decided that BA decided that this is the analysis if you've got an immigration decision. I have no problem with that. The point is, that's been stripped out of the statute. That's now a non-issue, whatever the rights and wrongs of it. however fascinating that case would have been if ZA had come higher, we just don't need to deal with it because the statute changed in 2014 in that regard. Then it says, Court of Appeals says in the same paragraph, paragraph 53, well, ZA decided that there is a gatekeeping role. Well, it depends what you mean. Gatekeeping role that means you stay out of Part 5 of the statute, I certainly don't accept. That could possibly be right, even as the statute was then crafted, but it's not, in any event, the answer to the statute that we are dealing with. And finally, the Court of Appeal says they rejected the submission made by my learned juniors that ZA was really a case about the Secretary of State's procedure. But that submission was correct. ZA is a case about the immigration decision part that you are allowed to deal with under your rules because of the 1971 Act. Finally, to note on the 2014 Act, it is worth being aware that in 2014, Parliament amended Section 12. And I know I'm not allowed to rely on Section 12 as an aid to interpretation, so I don't, because that, again, is what the Supreme Court said in BA. But it is a relevant part of the landscape when you're looking at the 2014 Act changes to have in mind that they thought about Section 12 and they amended it. And I'll just give you the reference once I can locate the document. It's in volume 5 at tab 28. And it's to be found at 1658. Very grateful. So at 1658, you'll see the Parliament thought about Section 12, which was on the statute book, and they amended the definition in Section 12 in readiness for that to be brought into force if it was brought into force, which it hasn't been. So it's still live and in mind. And Section 12, which is at page 1302 in tab 17 of volume 3, is the one that says asylum claim, the definition is amended to bring in the fact that if the Secretary of State declassifies it under the immigration rule, it doesn't count. 1302 in tab 17. Anyway, it's a point we deal with at 16.4 of our case. ZT we deal with at paragraph 44. That was the House of Lords case that preceded BA. If I'm right in my explanation of ZA, then I have no difficulty with ZT. Because, again, it was a case about that part of Lord Justice Sheeman's judgment in Kakebe, and it was about immigration rules, and it was about you could refuse leave to enter or to remain. It is, however, worth having in mind about ZT, if you get there, that ZT was actually a case about the meaning of Rule 353, and it was considered to be important because the question in ZT was, does the Secretary of State have a duty to consider on the merits the new submissions? This is Lord Phillips, paragraph 15, at page 1078 in the House of Lords. But it's a point made in the Court of Appeal in the same case, at paragraph 15 in Lord Justice Sedley's judgment. It's all dealt with in our printed case. Interestingly, Lord Justice Buxton pointed out it didn't matter because there would have to be a duty of due consideration whether or not it was through Rule 353. That was his paragraph 21. So that was the position in ZT. But Lord Hope dealt with it in BA. He explained at the very beginning of his judgment, paragraphs 1 and 2, that ZT was a case about the meaning of the rule. it was not about the statute. And we're concerned with the statute, and so are we. Sir James submits that if you look at the explanatory notes, it shows you that the intention in 2014 was to limit immigration appeals. Well, what the explanatory notes actually say, if you come to look at them, is that this is a restructuring from 14 appealable decisions down to 3. It's paragraph 6 and paragraph 19 of those explanatory notes, which are in the same volume that we were just in, volume 5, tab 28. There's nothing anywhere in those explanatory notes, because it's all words that deals with fresh claims or addresses fresh claims. What you do rather interestingly get from those explanatory notes is the point I made earlier about the synonym where rejection means decision to refuse. I showed you section 83 as originally previously enacted at page 1361, and the explanatory notes tell us that that's been fused into the new section 82. We don't need that provision now we've got 82. So what was previously rejection is now decision to refuse, but as I explained 2 hours ago, that's not an issue between us. I will just give you the paragraph references, 19 and 88 at 1666 and 1678. What was previously the language of rejection is now the language of decision to refuse. Unless I can assist you further, those are our submissions.
Just ask you about paragraph 33 of BA, please.
Yes.
Lord Hope. It's in pretty absolute terms. I think you're telling us that this was just about the question of whether you make an immigration decision or not. That's what the main concern was in BA. Is that, have I understood that submission correct?
No, that's my submission on ZA.
On ZA. But it's a pretty absolute statement that Lord Hope makes at 33, where he says that Rule 353, as presently drafted, has no part to play in the legislative scheme.
Yes. And it is fair to say, and certainly Lord Neuberger thought this, that the whole picture presented by the Supreme Court emphatically in BA does have a premise at its start. And the premise at its start is an immigration decision, so that you can appeal it, which he accepts at the start of his judgment. And therefore that picture is one applicable in that situation. But he's not needing to grapple with whether the rule might have a role as to, for example, refusing leave to enter. And what I've just described is exactly what Lord Neuberger thought in ZA. So, providing you've got the appealable immigration decision, refusal of leave to enter, then for the rest of it, what's a claim under the statute, it is a comprehensive code, and Rule 353 has no part to play. And my submission on this appeal, given the statute as it is, which is why if I'd been bolder, although no doubt it would have been a mistake, I might have taken it shorter, is that that is a non-issue. Because the only thing we have is a claim under Part 5, using the same language. So whether it was right or whether it was wrong, it doesn't impact on what we have, unless Sir James can do exactly what the Supreme Court majority declined, which is go back to Benion and Onibayo, which would actually mean saying that BA was wrongly decided, which is not their submission.
Well, we'd better listen to it now, hadn't we?
Thank you.
On a point purely of information, we've got the current Rule 353 at the back of Volume 1, page 646. I think, correct me if I'm wrong, that came in October 2004. Where do we find the previous Rule 353, Mr. Fordham?
Just one moment. So the previous to 2004,
Well, we've got a version at 646. I think I gathered that it came in October 2004. Correct me if that's wrong.
no.
What was the version before then?
Yes, it's at page 749 in volume 2, tab 8, which is the immigration rules as at August 1996. And what happened was that in 1994, they were, I think, material change of circumstances language. Is that right? And then Sir Thomas Bingham laid down the acid test in Onibayo, and then the immigration rule reflected part of his test. And so the sequence is as follows. Immigration rule 90, as it stood in 1994, volume 2, tab 6, starting at page 728. Immigration rule...
Hold on, please.
Sorry. Do you want to look at them?
Then we just note them down. 728,
Yes, I'll get you the exact page for the rule.
please.
Yes, it's 729, Rule 346. 729, Rule 346.
Yes.
And then what happens at Volume 2, Tab 8, at page 753, is you get a Rule 346, 753, halfway down the page. And that's a change that comes in August 1996.
What page are we on here?
753,
Yes.
the new Rule 346.
Yes.
346.
And it's part of Sir Thomas Bingham, but it's not the part about ignoring things that could have been raised before.
Thank you. And that continues until 2004.
In I'd love to tell you we had a fascinating time going through the history, but we certainly went.
Well, let's
through it.
proceed on that basis.
Yes,
unless-
October 2004 is when it changes. And if you want to see how it is in October 2004, you'll find it quoted in ZT Kosovo at paragraph 9. And the page reference for that is 1077 at the top. Sorry, 1076 at the bottom. 1076.
Are you saying that's a different version from the one we've got at the back of Volume 1?
It's not different. No difference in substance, but when people say it came in its present form in 2004, the most reliable place I can give you is the bottom of 1076 for that. If I need to bring to your attention anything that was material in the different formulations, then I will do so. I am not currently aware of anything.
Thank you.
Yeah.
Mr. Toll, I imagine you don't want to follow your leader? Do you wish to follow your leader?
I don't, thank you very much.
No. As he was dispensing with the lecterns, I thought that probably he didn't want you to. Sir James.
Ladies, my lords, I'm going to start very, very briefly with the facts, just so we have the chronology and the basis on which it comes to this court in mind. We're dealing with a serious offender. The list of offences is set out in our case at paragraph 6. A deportation order was signed and reasons provided in July 2013. He appealed against that deportation order to the FTT, relying inter alia on his Article 8 rights, and that appeal was refused, and his appeal rights were eventually exhausted on the 1st of May 2015. 2 weeks later, he made his first lot of additional representations or further submissions. On the 23rd of June 2015, the Secretary of State concluded that wasn't a fresh claim for the purposes of 353. There were then further submissions following the birth of his son on the 28th of July 2015, and the Secretary of State reached the same conclusion under 353 on the 31st of July. He then appealed again to the FTT on the 5th of August 2015, and they, 2 days later, declined jurisdiction on the basis that there was no appealable decision under Section 82, given the Secretary of State's conclusion under 353. And so on the same day as that refusal arrived, a JR claim was issued, challenging the Secretary of State's decision, and later amended to challenge the FTT decision declining jurisdiction, which is why you have both as appellants, or both as respondents, rather, in this appeal. Two arguments were mounted. Firstly, it was said that under the 2002 Act, as amended by the 2014 Act, 353 has no role to play, that point, the point we're arguing about. And secondly, that the Secretary of State had been irrational to conclude that the further submissions had no reasonable prospect of succeeding before an immigration judge. Both of those arguments were rejected by the upper tribunal, which heard the judicial review. Their decision was the 16th of February 2016. There was then an appeal to the Court of Appeal seeking permission to appeal on both grounds. That's the point of about the meaning and effect of the 2002 Act as amended, and the irrationality decision or challenge. The Court of Appeal gave permission on the first, but not on the second point. And so the premise for this appeal is that there is no realistic prospect, as found by the court, that the immigration judge would consider deportation to breach human rights. And he nevertheless claims still to be entitled to appeal despite that finding.
No, the upper tribunal found that the Secretary of State was not irrational, so to conclude. That's not the same as the upper tribunal itself concluding.
Well, my lady, that's true.
No reasonable prospect.
Casts the thing in terms of an appeal, yeah. But the Court of Appeal's decision from which this appeal proceeds on the remaining ground, the order of the Court of Appeal was the 4th of May 2017. So those are the facts. And I wanted, bearing in mind my lady's indication about timing, I wanted to make 6, I hope, short submissions. Firstly, there was and is a powerful public interest reason for 353 to operate under both the old and the new legislation to limit claims to those that pass the tests within 353. 353 itself, which we've set out in our case at paragraph 24, we've quoted it extensively and given you the date on which it came in, which was indeed October 2004, as my Lord Wilson recalled. 353 applies only to a situation in which the claim in question, or a claim in question, has been made and finally determined already, and there are then further representations or submissions thereafter. And the evident intent of 353 is to weed out further submissions from the appellate system if they are not, quote, significantly different from those already made in the claim that's now finished. So it covers, by definition of significantly different and that concept that it uses, repetitious claims, in other words, directly overlapping claims, and claims which, even if notionally adding some new fact, does not create any realistic prospect of success. They are both elements of the significantly different test that it sets out. And there is a clear public interest, we respectfully submit, in having efficient and effective mechanisms for dealing with that range of cases as defined. In other words, cases that fall within 353, in not providing repetitious/fanciful claims with a second right of appeal. So 353 can be seen to be designed, if you will, to deal with its alternative. And the alternative at a basic level is that claim is a self-creating concept. The individual concerned can simply create a claim and thus a right of appeal by the mere dint of advancing new submissions after a previously unwelcome judicial reverse. He could do so on my learned friend's case, even if the claim was repetitious and there was nothing new. Indeed, that is the factual premise of this appeal, given the refusal of permission by the Court of Appeal. And the result, if that is right, would be precisely the result described in the Wakar decision, which was a decision of the upper tribunal, and most of the recent decisions, or the more recent decisions, are in Authorities Volume 4. Can I just invite you briefly to take up the Wakar decision, which is Volume 4, tab 24, electronic page 1458. It starts at 1449, but I want the conclusion section at 1458. And what the experienced and expert upper tribunal, in this case it was upper tribunal Judge Coker and upper tribunal Judge Kabedi in the Wakar decision, although as we'll see in due course, that decision and its essential reasoning was upheld when the Court of Appeal refused permission and produced, when they did so, a fairly detailed looking written set of reasons for doing so. I'm going to come back to that. But just paragraph 18 is the one I want on page 1458, if you'd just cast an eye over that.
Paragraph 18.
Paragraph 18, my lady, sorry, yes.
Thank you.
If the applicant is correct and any submission amounts to a claim, the response to which is an appealable decision, this would result in an applicant being able to make numerous consecutive claims that would result in numerous consecutive appeals. Although each of those could be certified, the mere existence of such a scenario would result in it being virtually impossible to reach finality.
That means certified is clearly unfounded, does it?
It does. I think he's referring to certification, and I'm going to come back to certification. Is certification an answer? A complete answer in due course.
Way of breaking the virtuous circle.
Exactly. But that's the conclusion that obviously concerns the courts. Consecutive appeals with finality in an area where finality is of obvious importance being compromised. And that was also the concern, if you look to the Court of Appeal's judgment in the present case. That was obviously the central concern that the Court of Appeal had. If you go to the appendix in the core volume, and you go to the Court of Appeal's judgment, paragraph 47, on MS 170, if you're on the electronic numbering. So it's MS 170, paragraph 47. And can I just, rather than me reading them out, can I just invite you to read, for this purpose on the consequences, paras 47 and then 54, if you would. I said that we get a similar point from the Court of Appeal refusing permission in Wakar. The record of that decision is set out in extenso in another upper tribunal case to which I'm going to return, called Hussein. It's in the same volume we had open before, volume 4. Put away the core volume and retake up volume 4 if you would. Hussein starts at page 1476, electronic numbering, but the bit I want, which is the quotation, quite an extensive quotation from the refusal of permission in Wakar, starts on 1498. The decision of the upper tribunal in Hussein. So this is a decision of Peter Lane, who's then an upper tribunal judge, as you know, and Davjay, and the Wakar decision 1498. It's within the Hussein judgment, paragraph 28. You see the bold paragraph number, halfway down 1498, but there's an extensive citation running over the next 2 and a bit pages and finishing just above the bold R brackets Robinson on 1500. And the passage I want for present purposes is paragraph 23 within that quotation. So this is a quotation from Lord Justice Beatson giving fairly extensive reasons for refusing permission to appeal from the Wakar decision that we've just seen. I'm sorry if that's all rather convoluted, but this is the only record of it we have. Can I invite you just to read paragraph 23 within that quote on page 1500? So that is the obvious and acknowledged, repeatedly acknowledged concern. And this first submission finishes with the obvious point, which is that Parliament can be taken to well understand that public interest and would be likely to be very clear if what it did in legislation was to undermine that in any significant way.
Somebody's going to mention the amendment to section 12.
I'm going to mention it later on.
I'm only making the observation. I'm sure you will. Yes.
They are, but I'm going to deal with that. You've seen that there's been some consideration of that already in the BA case, but I'm going to come back to it. This is the bit that had the legislative provision that looked and smelled a bit like 353 in it, which has not yet been commenced, despite having been enacted in 2006, I think. But I'll come back to that. That's the first submission, the public interest point. Secondly, we submit it is entirely coherent for 353 to work in combination with Section 82 appeal rights and for the position thus to be that it is for the Secretary of State to decide that something is not a claim for the purpose of those appeal rights and if they do not pass the 353 threshold. That is that coherent position. We also see, if you still have the Wakar refusal open within Hussein, and you look at paragraph 19 in Lord Justice Beatson's quoted refusal of permission.
Have we got that?
We haven't.
Yes.
Got 16 and 20 then.
Well, I'm so sorry, I'm in the wrong Wakar. I knew I was going to get confused. It's paragraph 19 of the Wakar decision itself, behind tab 24. I'm so sorry to mislead. And that paragraph 19 is 1459 on the electronic numbering. paragraph 19 of WACA at first instance. So that is, we respectfully submit, the coherent position. Paragraph 19 of the upper tribunal, as we know from the Lord Justice Beatson refusal of permission, the Court of Appeal effectively decided that was right. But we get exactly the same acknowledgement of coherent position and the working in combination of the statutory appeal rights and 353 from the most recent decision in this area, which is the decision of the Court of Appeal, Lord Justice Sales and my Lady Arden, which is the VM Jamaica case in the same bundle, tab 27, starting at 1509. Again, extraordinarily convoluted procedural history with all sorts of different routes being followed, but really the only paragraph it might be thought that one needs for present purposes is paragraph 28 on page 1519. This is in the judgment of Lord Justice Sales, with which, as we see from page 1528, my lady agreed. Mm-hmm. Paragraph 28, could I just invite you to read that? Agreeing, in effect, with the WACA paragraph we've just looked at. On the same point and the final citation for the coherence of that position, could you go to bundle 3 and to Lord Neuberger in ZA Nigeria? First time I'm going to go to this. So ZA Nigeria, sorry, that's bundle 4, tab 23. Same bundle, tab 23. You note the Court of Appeal, Lord Neuberger, Lord Justices Laws and Sullivan, both experienced in this area. And the paragraph I want for present purposes is paragraph 21 on page 1438. And can I just do an erratum? We've misquoted, we've given you the right words but the wrong paragraph. In our case at paragraph 43, we call this paragraph 22. It is in fact paragraph 21. So 21 is the one we want, 1438. And if I could invite you to read, because it's part of the reasoning, from the fourth line of para 21, if Rule 353 can be relied on, then on receipt of a purported renewed claim, which I shall refer to hereafter with further submissions, the Secretary of State can decide that it is not a fresh claim and then decline to make a decision on whether or not to refuse leave to enter, etc. In that event, there would be no decision which could give rise to the right of appeal under Section 82 as explained in Kakabe. A decision under Rule 353 is not a decision to refuse relief. The relief which the further submissions seek it is a decision that the further submissions do not amount to a fresh claim, i.e. that it is not a claim at all.
Yeah, let's not forget, all this is in the absence of recent binding authority.
It is. He's addressing the point as a point of principle, yeah. And then he comes to see what the effect of BA in Nigeria is. Yeah. Exactly. But it might be thought that was rather a convenient way of doing it, to see whether the issue as it arose in that case, what would be the answer in principle, and then is there any binding authority that covers it? But that's how the thing is conceived by the Court of Appeal in that case. And it was
only a small point, but it was an interesting point that Mr. Fordham made. Do you remember the section in the Act which deals with claims from abroad?
Yes.
And Mr. Fordham showed that Rule 353 doesn't apply to claims from abroad. So, at some point convenient to yourself, Mr. Eady, will you deal with who decides whether that's a claim from abroad? Because your rule doesn't apply to it.
Can I come back?
Yes, do.
But you'll see that the analysis, in principle indeed, as my Lord rightly points out, but the analysis here is it's about a claim. Is it any old claim? Is it a purported claim? But that isn't linked to immigration decision or anything of that kind. It's about and focused on claim, unsurprisingly, because the issue as to what is or isn't a claim is not an uncomplicated business. So that's the second submission. The third submission is that there is no rule of law objection to that coherent position as described in WACAR, in paragraph 28 of VM Jamaica, and by the Court of Appeal in paragraph 21 of ZA. There's no rule of law objection to that approach for three short reasons. Firstly, because...
Is this your third point?
This is my third point. It's got three sub-points, an A, B, and C, if it makes it easier. A under this is because a person will already have had at least the opportunity to challenge and appeal and get before a court before you even reach this stage. Secondly, and more significantly, because it remains possible to challenge the decision that this is not a fresh claim by way of judicial review. Indeed, that is what happened, as my Lady Arden may well recall, that is what happened in VM Jamaica, where for a variety of reasons a merits challenge and the JR were muddled up together up to the level of the Court of Appeal, which then disentangled them. It took a little disentangling, but disentangled they were. And thirdly, because, and for good measure perhaps, there is no such driver, in other words, to move from a position where you have judicial review as a possibility for challenging that decision, with its rationality standard and other public law principles that would apply. There is no driver in any of the relevant international instruments, for relevant purposes probably the Refugee Convention and the ECHR, to suggest that JR of that sort of decision would be treated as being inadequate. And that is because there is nothing in any of those international instruments to suggest that you need a right of appeal following rejection of further submissions of the kind that are contemplated by 353. And in any event, for the more fundamental reason, that even without the prior opportunity to appeal, and you only get to 353 after that appeal system has been exhausted for the first time, even without that, judicial review has been held in numerous cases to be sufficient to provide the requisite rule of law protection, if I can call it that. And we've cited a series of cases going back to Vilvaraja all those years ago in our case at paragraph 67. I don't take you to those.
And judicial review does play an important part in dealing with immigration cases. And there are a number of matters which go by. It's accepted they have to go by judicial review outside the immigration system.
Yes, we respectfully entirely agree. But you'll have seen that the live debate that often happens in some of these cases in our area, the live debate about what all this appellate structure means and how it sits with 353 is often accompanied by or sits alongside the usual debate about whether things are to be treated as precedent fact. And therefore, for the court to determine, rather than for the Secretary of State to determine, subject to the application of Wensbury challenges and all the rest of it. So you often have those two together, but my lady is right. My more fundamental point is there's nothing in those international instruments to suggest that JR is not an adequate access to court for present purposes. And of course here, we've got JR loaded onto a system in which there is you've already been around the appellate route once already. That's the premise on which 353 sits. My fourth submission will take a little bit longer, but it is that the legislative and jurisprudential history supports that approach and that outcome. In other words, a coherent approach identified in, for example, para 28 of VM Jamaica. I'm not going to go back over the history and the way in which the case law developed and the legislation developed alongside it. We've set that out in some detail in our case between paragraphs 16 and 47. And the court may find of interest and use. I simply give you the reference, but if you have bundle 4 open, you can flick to it. Behind tab 24, the upper tribunal decision in Wacker, if you go to 1465 in that, you will see quite a helpful table which sets out the old and the new, at least in tabular form, so one can see how a particular provision has been changed, and that, at least when preparing, I find quite a useful table. Anyway, it's there if you want it. But the various stages of that development, if I can just pick out 3 or 4 of them, still under the 4th submission, so we don't get the numbering too confused, which is legislative and jurisprudential history. But the first point is that from the outset, both the courts and Parliament have shown themselves to be very alive to the powerful public interests in avoiding repetitious and abusive claims after the appellate process has been round and has been exhausted for the first time. It was precisely that set of public interest reasons that underpinned the decision of Sir Thomas Bingham in Onibayo. Just invite you to go back very briefly to that. I know it'll be a familiar passage, but it's worth a revisit, if only briefly. It's in Authorities Bundle 2, tab 7, starts at page 730. But the relevant passage is about a page in length before he gets into the debate about who is to decide, but it's on page 745. And really the passages that are of most interest, it might be thought, are firstly the passage culminating in the citation of Ladd and Marshall between B and C on page 745, using the MS numbering. If I could just invite you to remind yourself of that. And then the acid test, as it were, I say as it were, the acid test so described below or just by H, and then over onto 746A. Not sure you really need the Justice Stuart Smith citation from the VIN, which sits between them. But
yeah.
Those two, again, very, very familiar. And you'll recall that in that case, the Secretary of State was mounting an argument that said you only get one go at it. You can't have another claim for asylum. You only get a single crack at it. And that was rejected by Sir Thomas Bingham and the Court of Appeal, but it was rejected whilst putting in place the principled constraints that you see in those two passages. Because otherwise, unless that hinterland was properly policed, the case for one claim only would have been a great deal stronger. And the hinterland is indeed policed by reference to the public interest in avoiding there just being repetitious claims. How do you do that? Well, you do it by reference to these principles. And that is the start, in essence, of what became 353. So it was this decision that led to Rule 346. If you recall, the numbering's changed, but the substance a little bit, but not materially. But 346 you were shown, and we've quoted in our case.
Do you mean the second version of 346?
Yes, the longer one, with the A, B, and C.
The one we've got at 753.
Yeah.
So that follows on, does it, pretty quickly after the Onibayo decision?
That's my understanding. And it then becomes 353, so this is the source of that rule, effectively.
That looks like a good point at which to pause. Thank you. Well, we'll adjourn now and look forward to hearing from you at 2 o'clock.